Hello, everyone. Harry here to talk about an important victory for the challengers in the United States District Court for the District of Columbia. Important on its own terms, important for what it maybe suggests about other cases, although as to both those matters of importance, a big asterisk is that we're still at the district court level and these bigger issues are certainly going to be decided at the Court of Appeals or more likely the Supreme Court. Okay. Kathy Harris was a member of the Merit Systems Protection Board. She had an appointment that ran until 2028. And the Merit Systems Protection Board is part of a whole panoply of protections and administrative processes for people. It hasn't before been people who are just fired en masse, but individuals who think that their employment contract with the United States has been violated. There's a whole series of administrative remedies within the executive branch. That's what the Merit System Protection Board does, with the possibility of then judicial legal remedies after. But in order to be able to be independent and to actually have the expertise and the sort of insulation from politics to properly rule against the executive, properly apply the law that protects executive branch employees. The Merit System Protection Board is specified, has to be removed for cause. There you have again that for cause provision that figures in so many of these cases. And notwithstanding that limitation, the Trump administration fired her anyway with their typical charming, thanks for your service, goodbye. And she sued. By the way, the MSPB members are not simply apolitical. They are divided by party, and they have to come from certain backgrounds in expertise, and it's got to be merit system principles and selection and advancement determined on the basis of relative ability, all these things. So you have an independent agency with 3 members, and she was one of them. She was fired and she sued. Okay. Deep breath, because we're going into the law that governs here. In general, you would think it's easy, right? The law says you need cause. They didn't provide cause. End of the story. However, what the administration is saying here and will be saying in similar cases involving probably the Hampton Dellinger, the Office of Special Counsel, the National Labor Relations Board, a lot of things, is that there are some arrangements where people who are at the head of agencies exercise sufficient power that any limitation on the president that they have to be removed only with cause is unconstitutional. And the Supreme Court has generally endorsed that proposition for a lot of executive branch officials, but it has also and critically recognized an exception. This is back in 1935. I'll say the case's name because you're going to be hearing about it. Humphrey's Executor, but that was a case with the exact same provision as here. And it said there's protection for those people you have to fire them only for cause. That has stuck in the craw of conservatives all these years. And the Supreme Court also has indicated a real readiness to revisit it. Indeed, already has revisited it in a couple cases. Celia Law is the big one involving the Consumer Financial Protection Bureau. And what they said in that case is, hey, there's a guy in charge, a single person. That person exercises pretty considerable executive power, prosecutorial power. Therefore, you cannot have him or her subject to removal by cause. the president has to have unfettered ability. Okay, now back, however, to the Merit Systems Protection Board. We have a multi-member board, not a single board as we do in the instance of the CFPB. And we have also, there's a kind of a back and forth in the case about just how much power do they exercise. Is it because there are two things that are basically at issue in this line of Supreme Court cases. One is single person or multi-member, and the other is degree of power, especially prosecutorial power. So the judge here says first multi-member board. So that's straightforward, Humphrey executor. And also in many of the 35 pages of his opinion, there's an analysis of the kind of power that the Merit System Protection Board exercises, how it's not final. Essentially, you can call it advisory, and for that reason as well, it comes under the Humphrey's executive principle. Okay, so in a way, not surprising, and a very strong opinion, not simply saying it's a violation, but ordering her reinstatement. That, by the way, could be a whole nother tussle. The administration could well argue, we don't care if we broke the law, you still can't shove down the throat the appointment of a particular person whom the president doesn't want. And that could be a separate issue as well. But both of those aspects kind of follow from Humphrey's executor. And in that sense, Judge Contreras, the D.C. district judge here, could have been expected to do what he did. Now, though, the Supreme Court almost certainly is going to weigh in again. It was the one that did the CFPB case, and the Humphreys executor case is a matter of real controversy up there, and nobody would be surprised if the Supreme Court overrules Humphrey's executor and basically says an executive agency that has a multi-head and they do a lot of prosecutorial work or little, it doesn't matter. All of them have to be able to be removed by the president willy-nilly for no reason. The Constitution says next to nothing about removal. Nevertheless, it's a sort of principle that they've gleaned from it, that to really be, this is a real tenet of the unitary executive theory. To really be able to control the executive branch, you got to be able to fire people. Very Trumpian vision, right? You're fired. So, on the one hand, strong opinion, including especially in remedy, saying she gets put back on the board. On the other hand, temporary in the sense that it'll now go up on appeal to the D.C. Circuit, and from there, depending on what happens, it or a case like it, because it's not the only one where the Trump administration is challenging provisions of removal only for cause, will go to the Supreme Court, where, among other things, the Supreme Court will have it in its power to just overrule Humphrey's executor and do away with all these distinctions, or if they keep Humphrey's executor, to slice a different slice in terms of how much it matters that there are three rather than one person, how much it matters the nature of the power that is exercised. So in that sense, we've got to see the case as a little bit provisional, temporary, nevertheless emphatic, a really strong pushback, and a right pushback under the law as it now stands. So another blow against the administration in favor of the law by a district court, and those courts have generally been stepping up very admirably and encouragingly, given that so many other potential checks on executive power, for example, the Senate and House, are really absent and cowed. So there you have it. Kathy Harris back on the board, but the administration will challenge both the remedy and the actual ruling, and it will be in a higher court that will see this issue actually settled. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.